Go ahead, Attorney. Well, it's the defense's motion, so I guess I'll have the defense make their argument first.
Your Honor, and I will be doing the majority of the argument today, and Attorney Smith will be doing the rebuttal.
Oh, okay.
That's all right with Your Honor.
So, and just let me refresh my memory of the pronunciation of your last name.
Certainly. Solinger.
Solinger. Okay, I wanted to say Solinger, so I will try to keep that straight.
Thank you, Your Honor. I appreciate it. May I proceed?
Go ahead.
1,294 days. It's been 1,294 days since Logan Kruckenberg-Anderson received a cash bond of $1 million on January 12th of 2021. He has been imprisoned ever since. Logan respectfully requests that this court modify the $1 million cash bond that has held him in jail for over 3 years. Judge, we all know the law on cash bond in Wisconsin. Since these allegations do qualify as violent, the court may consider the protection and the safety of our community. However, cash must still be reasonable under the totality of the circumstances. In State v. Boyle, the United States Supreme Court declared that bail, quote, is not a device for keeping persons in jail upon a mere accusation. On the contrary, the spirit of the procedure is to enable them to stay out of jail until a trial has found them guilty, end quote. Therefore, excessive bail set in an amount higher than necessary to assure the defendant's appearance in court may violate the defendant's 18th Amendment constitutional rights. Despite being in jail for approximately 3.5 of his formative teenage years, Logan has used the last 1,294 days to better himself and his future. Though access to programming was limited when he first arrived in jail during the pandemic, Logan has been taking full advantage of services available to him for about 1.5 years now. He's done weekly one-on-one counseling sessions for his mental health. He attends Bible study classes every Thursday. And he has been meeting one-on-one with the jail chaplain, Pastor Watkins, weekly for approximately 8 months. Pastor Watkins is duly certified in theology and talk therapy, and he's been helping Logan to grow in his mental well-being as well as his faith. Per Pastor Watkins, Logan isn't someone who's just going through the motions. He's been taking their meetings very seriously, and he's actively working to better himself so that he may become a productive member of our community. 1,294 days is a long time for a case to be pending, and we acknowledge that there has been significant litigation in this case, but none of these delays were Logan's fault. Circuit Court Judge Vail held a series of hearings during the summer and fall of 2022, after which Judge Vail agreed with the defense's motion that law enforcement illegally obtained a confession from Logan through a series of unlawful police interrogations. The state was unhappy with this decision and appealed. Last week, the Wisconsin Court of Appeals affirmed the Circuit Court's decision in all relevant parts, continuing to suppress the illegally obtained evidence. In sum, since this $1 million cash bond was offered over 3 years ago, the state's case has only become weaker. The strength of the state's case, coupled with potential further litigation and further delay, is another reason to modify this bond. So, Your Honor, you must now ask yourself, what is the minimum necessary amount to assure that this young man appears in court? This 20-year-old who has spent most of his teenage years behind bars, who has no criminal record outside of these allegations, who has incredibly limited finances, who only has connections to the south central area of Wisconsin, and who is still presumed to be innocent in the eyes of the law. $1 million is an astronomical amount of money for even the wealthiest of our community to afford, let alone someone in Logan's position. Therefore, we respectfully request a modification to a signature bond. Thank you.
Attorney Cole.
Thank you, Your Honor. Just to be clear, with this, the violent nature of the offense, the standard is that the bond be not excessive rather than the minimum necessary, but the court can consider the need to assure the defendant's appearance in court, considering factors including the gravity of the offense and potential penalty, the violent nature of the acts, the character, and strength of the evidence, whether the defendant has been bound over for trial, whether the defendant has violated a condition of release, the residence and the reputation of the defendant. The court may also, as this is a violent crime, impose cash to protect members of the community from serious harm and the intimidation of witnesses. To achieve all of those purposes, the state believes that cash bond that has been previously set in the case is appropriate, necessary, and not excessive. First, the evidence in the case is strong. Aside from the position of the Court of Appeals, the defendant's remaining voluntary Mirandized statements and the matching physical evidence demonstrate his guilt. In the transcript from the interview he gave at the Rock County Juvenile Detention Center, which is in evidence and was affirmed, Logan describes how he took the baby from the mother's house in a backpack, describes how she was in the backpack, said how she was dressed, said that was the blue blanket with the fringes on the side and yellow ducks, how he stopped at his mother's house and transitioned her into another backpack, how he had his gun in his hoodie pocket or kangaroo pouch, some people call it. He described the route that he walked. He described how there was one set of tracks in the snow into the woods and one set out. He said, I was like 100 to 110 yards off the road, 5 to 10 feet from Harper, closer to the road than she was. They discussed where he shot her. He talked about head or heart shot and said, I took head because I couldn't guarantee I could hit the heart. He said, I heard her crying. After I laid her in the snow, she started crying. He said, that's when I shot her in the head. After that, I covered her up with the snow. He said, I did too really quick. I just did a quick glance and I saw that 2 black marks on her head, and I knew I hit her somewhere. When they asked where, he said upper forehead. When asked where the casings would be, he said would still be out there. He said it's a pistol, but the actual ammunition is .22 long rifle. Then he said, I got up and walked away and went down to my house and dropped the backpack off. He provided that backpack to Detective Feast. He got it from his mother's house. 1 shell casing was located at the scene. Another was located inside that backpack that he provided to the detective. His friend gave law enforcement the gun, just as he described it, with white writing on the side. He acknowledged that there was never a Tyler involved. He acknowledged there was never an Alex involved, as he had variously made up stories about other people. In his Rock County Sheriff's Office interview, also Mirandized, voluntary, and affirmed, he says, okay, so the firearm was like your guys, talking about the officer's weapons, but it was a .22 long rifle, and other than that, it was just like your standard .22 pistol. Trigger and everything was perfect. It had a magazine. The only distinctive thing about it was on the side, it had some white writing, and then it had little fine print on the other side, matching the firearm that he gave to his friend, who later gave it to law enforcement. He was shown still pictures from the video that showed him crossing the river alone with the backpack and back. He said, yes, that's me. It's kind of hard to see, but I know what I was wearing. I was wearing, you guys seen the baby's mother, in my black hoodie with like there was camouflage here, and then it said real tree. That was that hoodie. That's what you were wearing when you shot Harper? Yes. He admits that he texted to the baby's mother, confirming to her that his story was his best friend's mother took the baby. This is the same friend who he gave the firearm to. So you told her that this friend's mom had the baby? He said, I told her on a call to make her feel better. After you shot the baby? Yes. He admits that he was upset and texted to the mother of the baby when she and her friend had tried to contact the woman that he had supposedly left the baby with and check on the baby. He was upset that they were trying to find out what happened to the baby. The potential penalty in this case is obviously a life sentence. This provides significant incentive to flee should the defendant be released. The defendant does not have a stable lifestyle, good character, or good reputation. He does not have a home, a job, a business, children, or a family that he would care to stay for. He was not attending school. He was staying wherever he liked, sometimes with his mother, sometimes with a different friend's mother. As far as his character, his Snapchat messages reflect that he was talking to numerous underage girls. He was lying all the time. He was selling drugs. As far as his reputation, that is essentially just that he is a liar. Several of his friends told law enforcement that. Even his friend's mother, who attempted to support him, told law enforcement that he was a liar. Additionally, the defendant's prior behavior in jail indicates that he would like to violate the court orders and he would like to make contact with witnesses in the case if he had the capability to do so. As an example, March 1st of 2021, he's talking to his mother. He says, if the law says that the police couldn't interview him, then he's off the hook. All they have on me is the fact that I could have had possession of a .22 and that I had a casing of a .22 in my backpack from squirrel hunting, which they're trying to say was from killing my daughter. And the fact that there was 2 .22 bullets in my daughter's head. Logan tells his mom that she knows that he doesn't even use that small of a caliber for hunting. Logan tells his mom that it doesn't matter the size of the human, it would be a 7-mag or a shotgun, quote, if you were going to do it. Quote, and even then, if you do it, you make a getaway plan before you get out of the United States, so that way they can't find you. You get rid of the body and all the evidence so they can't trace it. Then you come back in a few months if you want. To his sister, apparently about the guards, quote, the next one that says anything, I'm going to slam their fucking throat into the bars until they're dead. Quote, if they want to charge me with murder, go ahead, fucking let them, but this time they better do it right. Another day to his sister, the first thing he wants to do when he gets out or gets into general population is get high. Numerous dates, including March 30th, March 31st, April 1st, April 2nd, numerous other times, he attempts to get his mother and his sister to contact the victim baby's mother for him, believing at the time that it is against his bond. April 2nd, April 3rd, other times he tries to call a number that he thinks is hers. He leaves messages, believing that it is a violation of his bond. April 4th, to his mother, he discusses numerous guns that he has access to, including the .22 that killed Harper, although that's no longer available to him. A 9mm he says is at the baby's mother's house. 2 .45s that they talk about being at his mother's house, one of which he says is his mother's and one he says is his. He says, quote, well, the FBI didn't find them, no way in hell. When they started interviewing, just by the way they started acting, I knew they were gonna start searching, so I took them and threw them in the fucking river. Quote, funny thing is they never found the 9mm or the .45s. Quote, I lost one gun though, I have no idea where the hell it is. I've been trying to think about where I might have put it this whole time, but I can't think of it. It's a big ass revolver too. It's kind of hard to lose it. Logan's mother says, the .357. Logan says, yep, the BFR, I got it from the same dude that killed my daughter. I got it from his grandpa for $180. He says to his sister on a different call, if he was guilty, he would have ran because he could have been out of the state before he was caught. Another call to his sister, he says if he gets out, he's going to get drunk and high and kill himself. Another day to his mother, he says he doesn't know why they think he is stupid enough to commit murder and hide the body where anyone could find it, then stick around to be questioned when he has a million places to hide. To his sister, he says, you do realize I'm fucked when it comes to trial, right? He's not getting out if he goes to trial because they have doctored up so many things that it looks like he did do it. Logan says it is almost enough to convince him, and he was the one who was there, He says, when it happened, he was down by the river contemplating shooting himself. He says he's killing himself on July 30th. A different day to his sister, he says, I'm fucked if it comes to trial. It's his word against a mountain of fake evidence. February 14th of 2022, he says he would make contact with the victim, the baby's mother, if he had her address, and he doesn't care if he gets a charge for it. They are going to have to put him down because he is not going to prison. If he gets out, he's going to get out of the States and never come back. If he goes down, he is going to go down swinging. September 18, he says, if he gets out, he may leave the country. His jail calls reflect that he would have liked to communicate with the friend who provided the gun to law enforcement, that he regularly lied to and attempted to manipulate the family members and the other people who talked to him, tried to get them to concur with his made-up versions of events, such as trying to get his parents and his sister to say that they remember him telling them that his girlfriend was pregnant, even though all of them say they don't remember that, telling them different stories about the gun, pitting them against each other and saying that he had conversations with them when he did not. He also made lengthy efforts to get to the victim's mother, including calling numbers he thought were hers, leaving messages, trying to get in contact with her underage female friends, believing that it was a bond violation, trying to get his mother and his sister to make contact with her against what he said was the advice of his attorneys. He also made numerous statements in jail calls about killing himself, at one point saying he wanted to plead suicidal, saying that he would harm or kill others on numerous occasions, saying that he had access to more firearms aside from the one that he stole and used to kill his infant daughter with, and saying that he was going to leave if he got out. He would leave the state, he would leave the country. Also, he is likely to attempt contact with witnesses and attempt to intimidate and influence their testimony based upon their reactions. I think, in addition to the fact that he's repeatedly attempted to make contact with witnesses, most notably the baby's mother, he also wanted to talk to the best friend that he provided the gun to. And I think it's important to note what his best friend told law enforcement at the time that they spoke to him about being intimidated by him and scared. Special Agent Mansavage's report indicates that the best friend, whose mother is the one who supposedly had gotten the baby, asked the defendant, "Why is somebody asking my mom about this baby?" The defendant says he's coming over to the best friend's house. Defendant goes to his bedroom. Eventually, the defendant produces the gun. Best friend says that he was hesitant to provide information to law enforcement because he didn't want anything to happen to his family and said, quote, "If something were to happen and freaking find out that I told anything," he cried, the best friend. He said the defendant wouldn't tell him anything. When the best friend tried asking about the baby, the defendant told him it was just someone from Monticello trying to start something. The defendant got very angry when the best friend tried to ask about the baby. So the best friend dropped the question, fearing that the defendant would physically hurt him. This is what he told law enforcement at the time. When the best friend was asked why he decided to turn the gun in, he was weeping and said, "I just got tired of it being there. I got tired of his stuff there. It was just freaking eating me up. I don't want any of that stuff there." After sobbing for a few minutes, he said, "I don't want to die." The agents told him he's not going to die. The defendant's friend said, "If he ever fucking gets out, I'm going to." He continued to cry. He said the defendant claimed to have shot a different person and had said on other occasions that he wasn't afraid to kill someone. The defendant's best friend, who he provided the gun to, repeated several times to the officers while crying that the defendant would kill him over turning in the gun. The people around him reflect fear. They reflect that he's a liar. They reflect that he committed this crime. They reflect that he's not close to a particular family member or a particular location, that he does not have the kind of ties. His mother seems to care for him in the course of the case, but he wasn't living with her, he wasn't staying with her, he wasn't reflecting particular care for her in any of his jail calls. He reflects an interest in speaking to the witnesses, in intimidating them. He reflects an interest in getting away. He reflects an interest in getting out of this. The evidence in the case shows that he is guilty. He knows what he's facing. If he has a reduced bond, it would be an invitation to flee, to intimidate witnesses, and to be a danger to the public with the numerous firearms that he's not even sure if he remembers where all they were. Yes, this case has been pending a long time, but all of the factors that the court needs to consider show that this is not an excessive bond. This defendant's crime, the nature of it, the potential penalty for it, his behavior since then, the statements that he have made all reflect that this is an appropriate bond that was set and should continue to be in place until the case is completed.
Thank you, IDA Cole. Attorney Smith?
Judge, I was advising a young attorney the other day before their first hearing. And I told them a couple of things, including to breathe. I gave them a little breathing exercise to do, and I told them to hold a water bottle. Because your hands conduct heat or lack thereof. And it's sort of the temperature control for your body. If you hold that cold water, it's going to lower your body temperature, and it's going to slow down that fight or flight response that you get in response to fear. The state's entire argument that I just heard appeared, and it's standard. It's not something we haven't heard before. But it's an attempt to elicit as much fear as possible. Because when you elicit fear, you elicit adrenaline and cortisone and chemicals in the brain that shut down the cerebral cortex, the part of the brain that controls in a person logic and reasoning and judgment. And it's what drives bad decisions. Courts are not supposed to be driven by fear and adrenaline and cortisol and the portion of the brain that controls that fight or flight response. We're supposed to look at logic and reasoning and judgment. And so the state, I understand why they do it, has picked all the possible worst facts and attempted to elicit as much fear as possible because they can't win on the logic. The fact is, all of these allegations, or at least the vast majority of them, were present 3.5 years ago. The state ended with, all of these reflect an interest in. Yet the most recent date was 2022 of a phone call. That reflects a scared 16-year-old, a scared 17-year-old, a past tense 16-year-old, 17-year-old, not present. March of 2022 is not July of 2024, especially when we know how brains develop in young men. Especially when we know that the difference between a 16 and a 17-year-old young man is a light years distance from a 19, a 20-year-old, a 21-year-old young man. The state talked about how in these phone calls, allegedly, when I get to Gen Pop, that was in, if I recall correctly, he was moved into Gen Pop in April or May of 2021. That's over 3 years ago. That was within months of this case starting. That isn't the present tense, that's the past tense. And the past is very different from the present, because if there were phone calls from 2 weeks ago, you would have heard about them from the state for sure. But there wasn't. Because Mr. Kruckenberg-Anderson of 16 and 17, completely divorced from the allegations of this proceeding, obviously I'm not going to get into those, made some poor choices because, in fairness, many of the adults in his life had failed him on many levels. It was early pandemic, he lacked structure, he lacked all the things that at that 17, 16-year-old, and 15-year-old self you need. He lacked them. And so there were some poor decisions. And again, I'm not talking about this case in any way, shape, or form. But that's 3.5, 4 years ago. The person here today is very, very different. And is more reflected in the judgment and the exercise of his use of time. Have you heard of any charges based on battery to law enforcement, threat to law enforcement, any improper conduct in the jail? Absolutely not. So if he really was going to, quote, bash someone's head into a bars, we would have heard about it over the past 3.5 years. But this court hasn't, because that is a caricature of reality, not what reality really reflects. Which is that this is not a young man who wants to violate court orders. There's been no allegation that he's violated a court order in any way, shape, or form during the pendency of this trial. I will be quick to point out that I understand the court saying, or the district attorney's office is saying that he attempted contact back in what would have been 2021. They didn't mention any attempted contact for the last 2.5 years. And even then, it was not a violation of bond because he wasn't released from custody. Either way, the fact is there's been no such contact even attempted, according to the state's presentation, for at least 2.5, 3 years. Meanwhile, the state's case has gotten substantially weaker. Now again, we don't know exactly how weak because we have a substantive ruling on the issue in front of the court, which is, were these statements involuntarily procured due to coercive police conduct? This court, the Honorable Judge Vail, before he retired, answered that question in the affirmative. He said yes. Court of Appeals said Judge Vail was correct. I understand that they reversed on the Miranda portion. Even then, they called it a close call. They didn't call voluntariness a close call. They agreed with us. And this court is well aware of the fruit of the poisonous tree doctrine. The court is well aware that there's a second question we have yet to answer, which is, in light of that ruling, how much evidence is excluded? It's not a question for today, but it's not as simple as the state is making it out to be in their argument today. It's not that they just get to waltz into court with everything that wasn't those statements. We don't know the exact contours of that, and we won't for some time. That's going to require judgment and reason that this court has not yet had the opportunity to examine and to consider. So when we look at the logic, not the fear-mongering, not the scary facts, not the attempts to say that the 16-year-old bravado is somehow a reflection of the reasoned judgment of someone 4 years older, who has now had the benefit of more than 3.5 years of constant counsel by defense attorneys. The court's well aware of the list of attorneys that have represented him. They're two different things. The state's argument doesn't hold water today, which today reflects a very different time period than January of 2021. It is true, when we look at the facts this court is supposed to consider, things like ties to the community, Mr. Kruckenberg-Anderson does not have a job, he doesn't have a business, he doesn't have a spouse, he doesn't have a family. Although, I think that's a rather tall ask for a 16-year-old who was then incarcerated for 3.5 years. Not entirely sure how you build a business out of the Greene County Jail while still following their policies and procedures, especially when lawyers can't bring documents in and out. It's hard to have a spouse when you are 16 years old and then in prison for 3.5 years. It's hard to get a job when you can't leave the walls of the Greene County Jail. It's hard to have a family when you can't leave the walls of the Greene County Jail. So we can't set bond according to impossible conditions. What do we know is that he doesn't and hasn't had any contacts outside of the state of Wisconsin at any point in his life. The few contacts he does have, he has maintained by calling his family weekly for years. And the fact that his family, 3.5 years later, is still calling him weekly testifies to the fact that even though there are lots of adults that have failed him, he has still put in the effort to love them in such a way that they're willing to stick around, to forgive them for many of their poor judgments, that he has an interest in maintaining a life in this jurisdiction beyond the walls of the Greene County Jail that is pro-social. So the community contacts weighs in favor of a considerably lower bond, not against. The strength of the state's case, although we won't know the full scope, is significantly weaker than it was at the time the bond was set. There isn't any present threat to any witnesses in any way, shape, or form. There's been no contact, no attempted contact, no allegation that these guns still exist, or that they were anything other than just bravado of a 16-year-old child. There isn't actually logical facts in front of this court to establish risk to the community that requires $1 million cash bond. There is no reason to believe $1 million cash bond is necessary to protect witnesses, to protect the community, or to assure his appearance in court. Because the state fails on every single ground that this court can consider, under the statute, logic and judgment demand a lower bond. Thank you.
Thank you, Attorney Smith. Let me first say that I did review the defendant's motion, and I do find that he is eligible to have this bond reviewed, given that he has not been able to post it. I did review the considerations that the court needs to consider. I'm going to go through some of them. The ability of the person to give bail. I've not really heard an argument from the defense that there's an amount that he could post, other than the statement that he has nary two nickels to rub together. I think it's abundantly clear that cash bail is appropriate in this case. I have considered the nature, number, and gravity of the offenses and the potential penalties. He's charged with a Class A felony. That is the highest charge in the land. And I'm mindful of the fact that had the state proceeded in a different direction, this is the type of case that would have been eligible for simply a denial of release from custody under 969.035. Obviously, that section wasn't pursued, but I'm aware that the legislature obviously considers Class A felonies to be different, and authorizes them to be treated differently under 969.035. And I'm considering whether the acts alleged were violent in nature. Obviously, that factor favors the plaintiff. I think the potential penalty factor also favors the plaintiff, being the state. And I've considered the defendant's prior record of criminal convictions and juvenile adjudications. To some extent, that factor favors the defendant. However, frankly, he was quite young when this case commenced. And so it's not as if he had accumulated many years of crime-free life. He's not a 40-year-old coming before the court with a lack of a prior record. Character, health, residence, and reputation of the defendant. I have not heard from the defense that he has a residence to return to. I've heard some arguments from the state regarding sort of a general instability leading up to the inception of this case. The reputation of the defendant, I think that would be a hard one to really address in a situation like this, where most of what we know happened after most of what we've heard about, I guess, his reputation is after the filing of the case. His health, we've heard a little bit from the defense about some things that he's been undertaking at the jail regarding counseling and what have you. His character, I think that the age thing cuts both ways in this one. I'm mindful of the fact that he's a very young man. I'm mindful of the science on brain development. I'm mindful of the fact that that science may have had an impact on some of what we've heard from the state regarding the comments that he made regarding what he would do if he were out, or what he wished he would have done, that kind of thing. But by contrast, he is still a young man, and that lack of brain development would still be a factor if he were released. And when I think about protecting members of the community, preventing intimidation of witnesses, frankly, protecting himself, I have grave concerns about the lingering impulsivity of somebody of his age. And I think that is a factor that cuts both ways. It cuts in the favor of the defense to the extent that I've already reviewed, but it also cuts to the favor of the state in the sense that I think he would be less able perhaps to conform himself to what would be required if he were released than somebody who would be older. The character and strength of the evidence, I think that cuts in the favor of the state. Whether he's been bound over for trial, my understanding is that he has. I think that cuts in the favor of the state. Whether the defendant has ever forfeited bail or violated conditions of release in the past, I don't really think that one applies, given that he has not been released during this case. Whether the defendant was a fugitive from justice at the time of the arrest, I think that cuts in the favor of the defense, in that there's been a representation here that there was some cooperation with the prosecution, policy against unnecessary detention of the defendant pending trial. Obviously, that cuts in the favor of the defense. I'm not inclined to reduce the bail. I'm not inclined to change what was set by the previous judge, although I'm mindful of the fact that he is entitled to review. The strongest considerations from the point of the defense in the motion were his young age and the amount of time that he's been incarcerated and how long this case has taken. And I am mindful of those considerations, and I'm certainly happy to hear that he is finding some services in the jail that have been of assistance to him. But I don't think that merely coming back and saying that, it's been 3 years and he's grown up in jail by nature of these proceedings, I don't think that that's enough to modify it on a Class A felony. Again, the potential penalty is very significant, and I am concerned about protecting the public, including the defendant, and preventing the intimidation of witnesses. I think, again, when we look at that potential penalty, when we hear some of the statements, and I grant that they are dated, I grant that, and that some of them probably did come from a place of just really, panic at being in custody and what have you, and being a young man. I take that and I understand that, but I think at the same time, the impulsivity and just having that huge penalty hanging over, a potential penalty hanging over him as a person released from custody, I just can't ignore the significant flight risk, the significant risk that desperation is going to take over and somebody's going to get hurt. So I am going to leave the $1 million cash in place. I thank you for your very eloquent arguments. Gave the court some additional things to think about that I hadn't considered after reviewing the motion. So from there, what scheduling can we accomplish today? Again, I'm mindful of the fact that he has been incarcerated for a significant period of time. I have not seen in the record a speedy trial demand. Certainly, if there's going to be one, we would set this trial in that fashion. I'm mindful of the fact that it appears that there are some motions that had perhaps not yet been heard at the time that the case went to the Court of Appeals. I guess I'll hear from defense counsel as to what motions you think still need to be heard.
Judge, I think there's a predicate question, which is that obviously the Court of Appeals is the intermediate court in this state, and the decision was issued July 25th of 2024. It's my understanding from speaking with appellate counsel, who is present in court today, that the state has 30 days to petition for review in front of the Supreme Court of Wisconsin. And I think the predicate question is, are they seeking to file a petition for review? Because that will obviously determine what we can and cannot schedule.
That's correct, Judge, and it's my understanding that they are considering petition for review. So the remitter would occur at day 31 under 80926. I would say that it would make sense maybe to schedule a status of some kind 31 days or thereabouts after the time runs from the decision. But prior to that, I don't think that we should schedule anything else. There are some other motions, though, as the court has identified, that once we have the case back, we would need to hear. But I do think that there is a likelihood of a petition for review, so I don't think that we should schedule anything else besides a status after 31 days out.
Judge, while it pains me to say it, given our previous arguments about the length of this case, I do agree with Attorney Cole that that's sort of the cart. Well, that's the horse in front of the cart, if I get the analogy correctly. We've got to get that taken care of before we can deal with the cartload of other issues that are still pending in front of the trial court. We wouldn't object to the status as requested by the state.
All right, and do the parties want to do that status by Zoom? Or
That would
do
be
we want
fine.
to do it in person? That would be fine. Zoom? Any objection from the defendant on that? No? To have a status by Zoom? All right, so let's pick a date in September. I think we should be good at any date in September, as I understand it, correct?
I believe so.
Yes, and while the clerk is looking, I'll just preemptively say the week of September 16th is rough for me, but I could do either the weeks before or the weeks, actually, week of the 9th and the week of the 16th. So the week of the 23rd or week of the 2nd is probably best for me.
September 5th, at 3 p.m.
That should be fine.
Does that work for the defense?
It works for the defense, thank you.
All right, so we will reconvene September 5th at 3 o'clock p.m. by Zoom for a status conference and further scheduling. Thank you. We're in recess.
Thank you, Judge.